Between yesterday and today, we have discussed a lot of the very basic concepts that are needed to obtain a patent generally, which are common to most countries. But there are some differences that are very important for you to know about as you go about patent protection in different countries, because it affects how you write your patent, how you file it, and how you prosecute it and enforce it. It's also important to consider in your strategy in deciding which countries you wish to file in, how to proceed based on these differences. So we're going to go through a study, a very brief study. The Manual of Patent Examination for the United States is more than, 1,400 pages, I believe. So what we're going to do is distill this down to about 10 or 15 slides and go through and look at what the main differences and similarities are for the different countries and offer some practical tips on how to cope with this and some tips specifically directed to the technologies of today's conference, which are software, electronics, and green. One thing we talked about this morning is words, invention, innovation, commercialization. What is an invention? What is an invention? It doesn't have to be a patent, right? Do we know what an invention is? We talked about things like promoting risk and not punishing failure so much. Right now, we're in the process of potty training my son, so I have to remember not to punish failure so much. It's a very, in a way, it teaches you patience, and so does the process of innovation. How much innovation results in a pioneering patent, a commercialized patent, and these kind of things. So what is innovation? What is invention? An invention is just something that you did. And unique to the United States, a method of medical use constitutes patentable subject matter, although I'm told that's changing in Japan within the next 1 or 2 years. And what I've done, I've gone essentially with the trilateral countries from broadest protection to least broad protection. Software, US is the broadest, and then EP and JPO seem to follow a similar standard where they're requiring some kind of technical effect. Business process, not patentable in Europe, patentable in Japan, but very difficult to get. Examiners are very difficult to be persuaded about that. Scheme, rules, methods of playing games, not patentable in Europe, sometimes patentable in Japan, especially with the video games. IC, similar to the United States, an absolute bar on medical treatment procedures. For a more detailed discussion of India and China, again, I turn over to my colleague, Mr. Kang.
Okay, I think if you look at India and China, some of the basic patentable subject matters are it's quite straightforward. When we move into the more esoteric areas like software, business process, China and India seems to have an absolute bar. But I think this is again policy considerations that perhaps if you look generally at this chart, that there are more crosses under India and China than in the other countries. And again, it could be because the Patent Act, the patent legislation needs to be perhaps amended to allow for greater scope of innovation in these areas.
We're not going to go through each and every element of this second slide. These are areas other than electronics, software, and green. I just simply include it for your viewing and later consideration with the understanding that, of course, traditional knowledge is a very controversial area, but it's outside of our field of discussion today. If we have time, we can discuss later, but this is just for your information, just some other areas of comparison. So what are our precautions? What are our practical tips particular to software and electronics? Now, we have to note that there is a great discrepancy between countries in the technical field. United States is broadest, moving to be narrower, narrower, narrower. And the law, just as the technology, see, one way to look at this, automobile. Really, how has the automobile changed in the last 100 years? You have four wheels, you have rubber tires, you have a drivetrain, you have a transmission, you have brakes, you have cooling. Now, there's hybrid engines, there are a lot of incremental innovations, but the basic operating system of the automobile has remained unchanged for a long time, so it's been easy for the law to adapt. Software, the operating system of 10 years ago is changed. 10 years ago, we couldn't imagine operating systems on handheld devices. Everything changes on a yearly, monthly, weekly basis in software, so it's very hard for the law to keep up. We do have a problem with the scope of claims and how claims are written. If you look at the controversial cases in the last 10 years in the United States, I would say maybe almost a majority of those cases are related to software technology. The companies we talk about, BlackBerry, Microsoft, AT&T, all been involved in the critical cases of the last decade. And because of the ephemeral and transnational nature, there are serious concerns about how we enforce. If the server is not in the United States and your claim is directed to a server, how do you get that guy? Now that they've told us that signals are not patentable subject matter, it's hard to capture that guy, so we have to be very creative. And it's actually a very exciting area to practice in because we can be creative in our strategies. Finally, it's not just what you say, it's how you say it. If you connect software to a technical effect or hardware, you may fall into the scope of patentable subject matter in countries such as Europe, India, and so forth. Do you want a method, or do you want a method inside a computer-readable medium? A pure method or a method that is stored in a medium? The Patent Office has told us that this is two different statutory areas, despite the fact that it looks very similar. Finally, yesterday, our colleague from USPTO came here and pointed out about the green highway, the patent prosecution highway, and interviewing. Our Director of Patents has pointed out that if you interview cases, you talk to the examiners, your chance of getting a patent doubles. If you follow what we call the interview highway, we can call it the interview highway, special PTO program, your chance of getting a patent goes up 6 times by using the patent prosecution highway. Why do I bring this up? Examiners are just as confused as we are about the state of the law. They are not attorneys in the United States. They are engineers trained to examine on a technical basis, and they are taught by supervisors who are also not attorneys to interpret complicated laws. If they're confused about the law and they're not the inventor, then it's up to us to teach them about the invention and convince them why it is patentable. And if you talk to somebody, instead of writing them a nasty letter, they're certainly more likely to consider your viewpoint. So this is just some advice, especially for the software and electronics areas. So this is part 1. Part 2, we're not going through all the details. The main difference between the United States and the rest of the world, and this is related to what we call the novelty requirement. You have to have done something new that has not been done before. How do we measure that? Well, the United States says you are first to invent, whereas the rest of the world says first to file. What does first to invent mean? It means we go before the filing date of the patent application. We go all the way back through all the notes the inventor made, all the correspondence between the attorneys and the inventors and the company. We go all the way back, and even there's a famous case where somebody was sitting in a restaurant and they wrote on a napkin their invention, and that evidence was used in court to establish the date of the invention. So that is the date that is the basis for novelty in the United States. Now, there are a lot more details. There have to be what is used against your invention. Some forms of published patents, some printed publications, some activities in the United States more than 1 year before the filing date, some offers for sale and things like that. But the main point is that you don't have to hurry up and go to the patent office. You just have to be the first to invent in the United States. Now, in EP and in the rest of the countries, we have something that we call novelty and absolute novelty. What this means is that you have to be the first one to get to the filing. You have to run to the patent office. If I'm the first inventor and Albin comes up with the same invention 20 minutes, well not 20 minutes, well let's say 1 day after me, in the United States I can get a patent in favor of him. In the rest of the world, he will run to the patent office, and if he gets to the patent office more than a day before me, then, or even 1 day before me, if he comes just before midnight and I come just after midnight, even though I came up with the idea first, he's going to get the patent. So you have two different systems going on and two different pressures. If you have offices in the United States and India and all over the world, you have to consider, if you're filing first in the United States, or even not, about this idea that even if you show up to the Indian Patent Office or any other patent office in the world second, if you were the first inventor, you can still get a patent in the United States. And this is the basic idea. Some of the details are very similar in a lot of the countries. Some are a little different. Albin, do you have comments on the novelty section?
Yeah, just a bit to add to what Miku has said in terms of, I think China and India also follows the absolute novelty test. Just a slight variation of the scenario. If I run to the patent office and in China or India and filed it today, but Miku can produce a paper that he published yesterday on the same invention, then I may not get my patent because it's not new or novel in the sense of the test of absolute novelty. The subject matter may have already been published or made known to the public prior to the filing date. But yes, India and China does follow the absolute novelty test. It's on a first to file basis like the rest of the world. So
that's the second requirement, novelty. Just to back up for a second, the first requirement is subject matter. The subject matter has to be appropriate for getting a patent. The second requirement is that it has to be new. Now the third requirement, even if you have the appropriate subject matter, and even if it's new, there's a third hurdle called inventive step or obviousness. There are variations in the different country, but the concept is basically the same. The idea that there might be differences that a skilled person in the art, and a skilled person, depending on the art, could be a PhD, it could be a high school person, it could be somebody with very little education, it could be a bachelor's. It depends on the level of the art. This person may find it obvious to make a change. You can't simply change the color of a computer from a green computer to a yellow computer and say, I've invented a yellow computer. That's a very simple example. Yesterday, one of the speakers brought up this KSR case. And in this KSR case, this was related to the accelerator pedal for an automobile. And it was related to taking something that had previously been done in a mechanical way and doing it in a way that involved an electronic signal. It was held that in view of some prior art, it doesn't have to be just one patent. It can be one patent, one book, what somebody put in an advertisement or a technical specification. But what the Supreme Court said is that it was obvious to simply basically switch from a mechanical way of doing something in an automobile to an electronic way. We've been doing that with the windows, other controllers, the electric mirrors, seat adjustment for many, many years. Why not do it with the linkage between the accelerator and the fuel injector or the carburetor? So this is the model and the basis. It can't be obvious. And this sounds subjective because it is. Different technologies will have a different level for what is obviousness. We have to compare the prior art with the claim, and we can make arguments. In the United States, we can even produce evidence that something was unexpected, and a result was unexpected. And based on these arguments, this is where the heart of lawyering is in a lot of cases as a patent attorney, working with the examiner without creating too much of a record that works against you later in enforcement. So what we do is we, again, interview the examiner. We talk to the examiner. So this standard of inventive step, or obviousness, is the third barrier to patentability. Similarly, we have EP standard. They call it something different, a problem and solution approach, and they have some different technical guidelines for how to interpret it, but it's basically the same idea. Japan, very similar to the United States standard, although Japanese examiners are more strict than American examiners usually. And then, Alvin, do you have points on inventive step for China and India?
No, I think you're right in the sense that I think the test for inventiveness or non-obviousness is fairly standard in most jurisdictions.
There's this economic significance part in India that at the end of the presentation I may ask for your input on this and experiences. So what are the precautions in this inventive step area? Software is unique. Usually there are lots and lots of patents in electronics and automotive areas. A lot of examiners rely mainly on patents. So sometimes we may get patents in the software area that are very weak because the examiner has not been able to find patent prior art. And we have a duty of disclosure, in the United States at least, to tell the examiner what prior art there is. It means different things in different countries, again, but if we talk to the patent examiner, we can learn how in each country to get a patent, and we can teach the examiner what the difference is. I was on the telephone last night with an examiner at USPTO for one of my cases, and in a 20-minute telephone call, we were able to totally clear something up, and he said, okay, well, I'm going to withdraw that obviousness rejection. And he said, I'm going to do another prior art search because now I understand your invention. I may give you a patent, or I may give you a new rejection, but I understand your invention, and we've moved the ball forward. This saved our client months and months and probably thousands of dollars. So I encourage in the software area to talk to the examiners. The terminology is complex. There are not a lot of patents out there. So this is very important. And this is our third bar, or our third requirement for patentability. Alvin, did you have any further comment on the third point, on the practical tips?
Yeah, I just thought I'd highlight the disclosure requirement in China. It's a bit unique in the sense that there is an obligation to disclose under Chinese patent law both adverse and non-adverse materials, something like in the United States, a continuing obligation. But that's as far as the law goes, but in practice, it doesn't really, the examiners don't really say when you should be disclosing it or how much of it you should be disclosed. So there are still ways in which patentees can still get around their obligation for disclosure, at least in China.
So, and this is our fourth requirement, is a disclosure. And essentially, at the beginning of our discussion and in past discussions, we've pointed out, what do we have to tell the patent office? We have to give the patent office a specification, and we have to give them some claims. A specification is designed, and we talked about this yesterday. I think Chid mentioned it, the quid pro quo. The quid is the specification, the pro quo is the claims. How much do we have to tell the Patent Office? Well, this is actually the subject of a current court case to be decided in 2010 in the United States called Ariad versus Eli Lilly. But the point is that you have to describe enough to show that you possess the invention as an inventor. You have to show enough to say that I invented this at the time of the filing date. The second thing is you have to show enough to teach the public how to make your invention. If we're going to use a patent system to advance technology, we get a right. We certainly get a right with these claims to block other people or to get a license from others once we get the patent. But in case we don't get the patent, or after the patent expires, or even after the patent is published, if you're reading somebody else's patent, you may say, this is an inefficient way of doing something, and you may get your own improvement patent. We talk about evergreening and things like that. Well, in order to have that advancement of the technology, you have to have a sufficient disclosure. And this is what we call written description and enablement in the United States. It's Article 83 and 84 in EP. In Japan, we have a similar requirement to, actually, it's similar to the United States in terms of the specification, similar to EPO in terms of the claims. We discussed about China, and India also has its requirements for specification and claims correspondingly. Again, talking about how fast software has evolved and continues to evolve as a technology compared with automotive and even electronics. Every day we're coming up with new standards. Mr. McKenna talked about the pools and the standards organizations that have developed and proliferated in the last 20 years. Short product life, changing hardware standard, means that what we need is different from we needed 10 years ago, 5 years ago. From the time you filed your application to the time you actually get your patent, you're going to have to go back to your claims, you're going to have to go back to your disclosure and look to make sure this is still what you want. Applications that you filed on a gamble 5 years ago, where you say, this might not be anything. Now, it's changed. I had an applicant who 10 years ago, he filed a patent application, and we had been fighting until actually 3 weeks ago for the last 10 years to get our client a patent. And finally, the examiner gave us the allowance. And now we've been modifying the claims quite a bit. And we looked back at each other, and 10 years ago, our feeling and our requirement was different. But we looked at this and we said, wow, this is cloud computing. We never thought that this would cover cloud computing. And he said, I thought this patent might not be so useful because the technology was 10 years old. But you're right. We've written this broadly enough to cover cloud computing. So the point is that you never know, based on shifting technology, the way that things are going to go. And there are different requirements in different countries. So we have to establish a baseline in what we submit in the first patent office so we can do this PCT thing and so that we can do this priority claim thing. What does that mean? We need to think about what our colleagues said this morning. Have an invention intake strategy that gets us the maximum amount of information from the inventors. We shake them upside down to get the information, and we make a good specification. So those are the four components. We have to disclose something to the patent office. It has to be appropriate subject matter for patenting. It has to be new, and it cannot be obvious. So our last topic is opposition, which we're going to cover rather quickly. What this means is after a patent has been granted, we find it. We say, this is an Amazon one-click patent. This is ridiculous. How can somebody get a patent on this subject matter? Well, you have to go back to the patent office or the courts in the different countries and try to fight to get that patent canceled. In the United States, we don't have something to do pre-grant. The only involvement we can meaningfully have is after the patent issues. We can go to re-examination, inter partes or ex partes, where we can submit prior art for that novelty part of the test and for that obviousness part of the test, for written prior art, we can go to the patent office and challenge somebody else's patent. Or we can go into court and file what's called a declaratory judgment with a high bar to cancel the patent. Of course, there's a cost to patent litigation, so we have to be a little bit careful in considering the strategies. But this is how you do it in the United States. EP has a more complicated post-grant opposition and nullification procedure. It's very contentious with inter partes. EP is one place where you can get patents canceled. And I believe you can also go in on a country-by-country basis. I believe we have a European colleague. You can, in Italy, you can do, within the national, the patent office, you can do a separate nullification in the courts, maybe? Right? Yes. So in some countries, you can go country-by-country basis, as well as in the EPO. And there's a very long and thorough procedure, but there are some time limits. Japan went through an evolution of pre-grant opposition, then abolished it. Post-grant opposition, and then abolished it. Now you have to go to Japanese court, and it's more of a litigation-style invalidity trial. Now for China and India, I let Alvin discuss if there's any points on opposition.
Well, I think in India, the experts are out there on India patent opposition.
Experts are out there.
Yeah.
And in China?
China, it's post-grant opposition.
Post-grant opposition. So this is what you do. And in different countries, a patent owner may or may not be able to substantively fix a problem. In the United States, you can do so. If you have a patent and there's a mistake, and it's an honest mistake, you can basically go for what's called a reissue to try to fix that mistake under certain circumstances. In other countries, and my understanding is India is one of those countries, it's very difficult to fix your patent in anything other than a clerical manner. So the question we come to, after all of this comparison, can it happen in India? And the question is, can it happen in India? What? Invention, innovation, commercialization. We keep talking about what Edison said. Doing things in a new way, trying hard. And one of our presenters pointed out the importance of Edison's comment on a teamwork, right? He said you have to have a team to support the innovation. We need a market for our products, and we need a way to get there. As my partner Chid mentioned, I've traveled to about 30 or 35 countries around the world. I've seen some incredible things, but I've never seen innovation done the way it is done in India. What everybody said, what Dr. Mitra said is true, that we're not doing innovation maybe as much as we should, and we're not doing a lot of things the way, but we're on the way there. But in very other ways, there are amazing forms of innovation that have been going on in India, and I would like to share some of that with you. Going through these 5 requirements, doing things in a new way. Do we do things in a new way in India sometimes? Working hard. Do we work hard? It's a lot of hard work. Teamwork. How many Indians does it take to change a light bulb? Hard work. Very, very important. Do we work hard? We work hard, you bet. A market. Do we have markets? Do we have lots of people riding back and forth on the trains and buses, and so many people I see on the jeeps and in the I was where was it on the way to Jaipur, and on some of these country roads I feel like I see a whole village on this tiny little vehicle. Market. We have a market. Do we have a way to get there? Yes, we do. And this innovation is being done in ways different than I've seen in any of the 30 or 35 countries I've been to in the world. Is it patentable? I don't know, but we're sure headed there, I think. We're sure headed in the right direction. We've come a long way. We've got a long way to go, and we're going a long way. So choose your patent strategy wisely and use the great things that we're doing and apply that in the area of software, electronics, and green, and we'll go a long way further. We have, how's our timing now? We have some time. Now, I think what we were going to do is just talk a little bit about strategy, or do we have questions? Alvin, I turn this over to you for a strategy and then maybe questions.
That sort of summarizes what you were saying earlier on the slides. You know, you need to choose your market and your territories very well. But yes, there is a cost involved in patenting your innovation. It's not like filing a trademark application, pay a few rupees for getting the filing application, and you got protection for 10 years. Unfortunately, patent protection is a bit more expensive than that. But you also have to bear in mind that if you don't do that, the potential loss could be even greater. Loss of your market share, you know, your products being ripped off, lookalikes appearing in the market. So you need to have all these commercial considerations. And obviously, at the end of the day, you know, maximizing your the exploitation of your patents. There's no point having a patent and then having it at the certificate filed away in the filing cabinet and say, oh, I own 10 patents, you know, I own 20 patents, I own 50 patents, and they just all certificates are all hung up on the wall, decorating your office. Go out and exploit them. You know, they can really bring your product out into the market. And just to end off, I mean, I'm just looking at those pictures that Migu was showing and the number of people that ride the trains in India. If someone could come up with an idea to create a kind of safety harness where you can just hook onto the train at any time, whether you're on the roof, on the window, in the front of the train. Think of the potential market that you would have for that kind of product, right?
Yeah. How many of you have been to Japan? If you ride the trains, you know the only difference between India and Japan is in India the people are on the outside, in Japan the people are on the inside. But seriously, thank you for allowing us to present, and Chair, thank you for moderating our session. I think we finished the